Mr. George Eke joins us this morning. He's a legal practitioner. As we just start off with the judiciary and also take a look at the legislative arm of government in this midterm assessment of both institutions. Morning, and thank you for coming on today.
Thank you so much.
Well, if we start off with the judiciary, I mean, in the opening sequence, we were talking about several cases, how important the judiciary is in coming across to the people. Yes, indeed, but the average person and then those up there can equally get justice from the judiciary. But in terms of the reforms that we've seen going on ever since the CJN came on, what significantly do you think has changed in the judiciary?
Well, a lot has changed in the judiciary. Unfortunately, the judiciary, the judges are just not there, probably on television, trying to talk about, what they have been able to do. Unlike the politicians that are seeking, camera light at all points in time, trying to hog camera lights. But the judiciary, by the nature of their profession, they do it in a very subdued and solemn manner. But the results are evident. Especially with the entry of the current CGN. I can say that, the last CGN, even though the tenure was very short, also did quite a significant improvement, in the judiciary. That is by way of reform. But more than anything, I think it started with my Lord Justice Alo. But Justice Aloma Mukhtar, that's the current CGN, has done a significant job. In quite a number of areas, in areas where by way of even the disciplinary procedures he has put in place. Before this time, of course, it was difficult to see a judge either suspended or even dismissed or whatever, or warned and all of that. Let us take a case study, the pension thief matter, which was quite prominent and quite topical, a few months ago. A lot of people are divided in opinions whether the judge should have been suspended. That's Justice Taba.
Yeah.
Of course, the CJN cannot come on television to tell you the reason, but some of us that are lawyers do know that it was the best decision anybody would have taken, the agency could have taken. The reason being that, people were arguing that, this is a discretionary thing. But in law, discretion has two aspects. You must exercise that discretion judicially and judiciously. Judicially suggests according to the law. Judiciously suggests according to the conscience of the society at that point in time. A lot of lawyers have always said that law is not about the conscience of society. The law is not about, it's stricto sensu what law is. And I disagree. I belong to the school of thought that says law is meant for the public. The moment the public does not get the value of legal adjudication, then it means nothing. So in other words, having exercised that discretion judicially, without exercising it judiciously, that was why he was punished. The reason is this. Let us agree that, the law was so obsolete or so outdated that a man who stole 27 billion, what was there for him as punishment would be maybe 250,000. At that point in time when that law was enacted, 250,000 was a lot of money. It was $250,000. Probably at a point in time when a regular graduate salary was about 6,000. I earned 6,000 a year when I started work. So when we are talking about misappropriation, nobody in the law did not contemplate that anybody could sit down in one place and embezzle 27 billion. But given the situation the way it was, the least the judge would have gone for is at least a custodial sentence. The Nigerian society wanted to see a man who stole that volume of money go to jail. And in the circumstance, even though the maximum was 2 years, and the judge chose to get it to run concurrently, he could have as well, with his discretion, gotten it to run consecutively.
In which case, notwithstanding.
It is even good enough or bad enough, depending on where you're coming from, that he was not charged for stealing, where he could get some 16 years sentence. He was charged for mismanagement. Mismanagement now attracted this 2-year imprisonment. But you see, in law, like my Lord Justice Mukhtar will say, it is no longer a two-way traffic where it is the two parties that are in court. There must be justice for the society. In that circumstance, the society did not get justice. In other words, a man who stole their 27 billion simply called his driver and wrote a check for 750,000 and walked away. So, in other words, even though they were arguing that the agency was playing to the gallery, but they needed to play to the gallery, given this stance that I told you, that law is for the society and not otherwise.
A host of people will say that the road to reforms is still a long way.
Oh, sure, it is.
In the judiciary.
We are coming from a very decadent level. A level where you have to almost like sweep and sweep and sweep to be able to clean the urgent table. The reason is this. The CJN has also, with the practice direction that she is just about to roll out now, in other words, trying to facilitate cases of, I mean, the most talked about cases are cases of corruption. Yeah. Quite a number of people, governors and all kinds of state officials that were maybe arraigned some 6-7 years ago. Some of their cases have not even been part heard. Why is it that way? Because there are quite a lot of hiccups here and there. A lawyer probably will first, their lawyer will first of all ask for bail. At the moment you give bail, the man goes to court and applies that his client is sick and must go abroad and all of that. After that, he probably puts a preliminary objection. If that does not, he says application to quash. If that does not work, he just finds someone that. And the moment that thing is decided against, he goes upstairs to the Court of Appeal. The substantive matter is still there. All of